Hello everyone. So today we are going to the ultimate conclusion of a suit, which is the most important point why people go to the courts or why the courts are approached is to get a judgment and a decree so that their rights can be enforced. So what are the rules and regulations? What are the rules relating to judgment and decree? They are as important as the rules relating to trial, because whatever is the contents of the judgment is very important, whatever the contents of the decree is very important for the purpose being served, that is he should be able to enforce that particular decree and he should be able to get the relief. So if a person gets a decree, it is very important for him to be able to access his remedy after that. That is why the importance of the judgment and decree. Judgment ಮತ್ತು ಡಿಕ್ರಿ ಎಷ್ಟು ಮಹತ್ವದ ಇದೆ ಅಂದರೆ ಕೋರ್ಟ್ಗೆ ಹೋಗೋ ಉದ್ದೇಶನೇ ಅದು. ಒಂದು ಜಜ್ಮೆಂಟ್ ನಮ್ಮ ಫೇವರಲ್ಲಿ ಆಗಬೇಕು, ಒಂದು ಡಿಕ್ರಿ ನಮ್ಮ ಫೇವರಲ್ಲಿ ಆಗಬೇಕು. ಅದರಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಏನು? ನಾವು ಡೆಫಿನೇಷನ್ಸ್ ನೋಡಿದ್ವಿ, ಜಜ್ಮೆಂಟ್ ಡೆಫಿನೇಷನು, ಡಿಕ್ರಿ ಡೆಫಿನೇಷನ್ ನೋಡಿದ್ವಿ. ಈಗ ಡಿಕ್ರಿ ಯಾವ ರೀತಿ ಇರಬೇಕು, ಜಜ್ಮೆಂಟ್ ಯಾವ ರೀತಿ ಇರಬೇಕು, ಯಾವಾಗ ಅದು ಎನ್ಫೋರ್ಸಬಲ್ ಆಗುತ್ತೆ, ಮತ್ತು ಅದರಲ್ಲಿ ಚೇಂಜಸ್ ಮಾಡೋಕ್ಕೆ ಸಾಧ್ಯ ಇದೆಯಾ, ಇವೆಲ್ಲ ರೂಲ್ಸ್ ನಾವು ಆರ್ಡರ್ 20ನಲ್ಲಿ 20ನೇ ಕ್ರಮಾದೇಶದಲ್ಲಿ ನೋಡ್ತೀವಿ. ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಲೆಟ್ ಅಸ್ ಹ್ಯಾವ್ ಎ ಸ್ಮಾಲ್ look at the things which we have discussed. See, these are all the stages which we have completed. The trial is over, arguments is over, now the time for the judgment. After the arguments, the judgment will be there. We have seen that there is a written argument also possible, or a oral argument is possible. After the judgment comes the decree. So first of all, what is a judgment? Of course, we have seen that according to section 2 subclause 9, the statement given by the judge on the grounds of a decree. So whatever the decree has been given, what is the ground for that decree? That ground is mentioned in the judgment. So any order or decree is passed. For that, what are the grounds? The thing which states, or the written statement which states that what are the grounds. So in one case, Surendra Singh versus State of Uttar Pradesh, All India Report of 1954, the court has given a definition of what is a judgment and what is its importance. So in this case, in Surendra Singh case, what had happened is the person, when he got the judgment, one of the judge, there were two judges and one of the judge was dead, and before dying he had already signed that document. So he had signed it, but he had not dated it. Then it goes to the other judge. When it goes to the other judge also signs, and the same judgment is pronounced in open court. Now there, on the ground that it was not signed by the judges at that time, there was a question. We'll come to that. So the final decision of the court, in that the court said that the final decision of the court is intimated to the parties and to the world at large by pronouncing this. ಸೊ ಜಜ್ಮೆಂಟ್ ಅಂದರೆ ಏನು? ಇವಾಗ ಒಂದು ಡಿಸಿಷನ್, ಕೊನೆಯ ನಿರ್ಣಯ ಏನಿದೆ ಕೋರ್ಟಿಂದು, ಅದು ಪೂರ್ತಿ ಜಗತ್ತಿಗೆ ಪ್ರೊನೌನ್ಸ್ ಮಾಡೋದು ಅಥವಾ ಹೇಳೋದು, ಅದು ಜಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳುತ್ತೆ. ಸೊ ಇಂಥ ಇಂಪಾರ್ಟೆಂಟ್ ಜಜ್ಮೆಂಟ್ಗೆ ಸರಿಯಾಗಿ ಅರ್ಥ ಕೊಡಬೇಕು. it should be in the proper manner which has been stated under order 20 itself. So order 20, first of all, section 33 says that as soon as the judgment is as soon as the hearing is completed, it has to be the judgment and decree both have to be pronounced, or judgment has to be pronounced and the decree has to be immediately drawn up. So what is a decree? Decree is drawn up after the judgment. So what is the requirement of that is stated in section 33. Now order 20 rule 1 says that once it is completed, now ಈಗ ಒಂದು ಹಿಯರಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆದಮೇಲೆ ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಅದು ಹೇಳಬೇಕು. ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಅಟ್ ಒನ್ಸ್, ಇಮ್ಮಿಡಿಯೇಟ್ಲಿ ಇದನ್ನು ಹಿಯರಿಂಗ್ ಆದ ತಕ್ಷಣ ಅದೇ ತಕ್ಷಣ ಇದನ್ನ ಜಜ್ಮೆಂಟ್ ಹೇಳಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಆದರೆ ನೀವು ನೋಡ್ತೀರಾ, ಇದನ್ನ ಇಟ್ ಈಸ್ ನಾಟ್ ಕಾಮನ್ಲಿ ಅಬ್ಸರ್ವ್, ಬಿಕಾಸ್ ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್ ಆಲ್ ದ ಥಿಂಗ್ಸ್ ದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಅಪ್ಲೈ ಹಿಸ್ ಮೈಂಡ್ ಆ್ಯಂಡ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಸ್ಟೇಟ್ ವಾಟ್ ಇಟ್ ಇಸ್. ಸೊ ದಟ್ಸ್ ವೈ he may post it for some future day. So when he gives it for a future day, then the notice should be given to the parties or their pleaders to come and attend, and that day it will be pronounced. So ಇಮಿಡಿಯೇಟ್ಲಿ ಆಗಬೇಕು ಅಂತ ಇದ್ರೂ ಕೂಡ ಒಂದು ಫ್ಯೂಚರ್ ಡೇ, ಮುಂದಿನ ಒಂದು ದಿನಾಂಕ ಕೊಡಬಹುದು. ಅದೇ ದಿನ ಆ ಪಾರ್ಟೀಸ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವರು ಬಂದು ಅದನ್ನು ಕೇಳಬಹುದು. ಆಫ್ಟರ್ ಸಚ್ ಡಿಕ್ರಿ, ಆಫ್ಟರ್ ದ ಜಜ್ಮೆಂಟ್ ದ ಡಿಕ್ರಿ ವಿಲ್ ಫಾಲೋ. ತಕ್ಷಣವೇ ಡಿಕ್ರಿ ಆಗಬೇಕು ಅಂತ ಹೇಳುತ್ತೆ. ಸೊ ದಿಸ್ ಇಸ್ ರೂಲ್ 1 ಆರ್ಡರ್ 20. ಫಾರ್ ದ್ಯಾಟ್ ದರ್ ಇಸ್ ಅ ಪ್ರಾವಿಸೋ. ಇದನ್ನು ಒಂದು ಪರಂತು ಇದೆ. ತಕ್ಷಣ ಆಗಿಲ್ಲ ಅಂದರೆ ಜಜ್ಮೆಂಟ್, ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಪ್ರೊನೌನ್ಸ್ ಇಮಿಡಿಯೇಟ್ಲಿ, ದೆನ್ ವಿದಿನ್ 30 days ಆಫ್ ದ ಹಿಯರಿಂಗ್. ಈಗ ತಕ್ಷಣ ಅಂತ ಹೇಳಿದರೆ ಫ್ಯೂಚರ್ ಡೇಟ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಫ್ಯೂಚರ್ ಡೇಟ್ ಅಂದರೆ ಯಾವ ಡೇಟು? 30 ದಿನ ಮ್ಯಾಕ್ಸಿಮಮ್. ಒಂದು ಸಾಮಾನ್ಯವಾಗಿ 30 ದಿನ ಒಳಗೆ ಜಜ್ಮೆಂಟ್ ಆಗಬೇಕು ಅಂತ ಇದೆ. ಆದರೆ ಕೆಲವು ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ಸಲ್ಲಿ, ಕೆಲವು ಅಪವಾದಾತ್ಮಕ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ಸಲ್ಲಿ ಕೋರ್ಟ್ಗೆ ಅದನ್ನು ಜಜ್ಮೆಂಟ್ ಬರೆಯೋಕ್ಕಾಗಲಿಲ್ಲ ಅಂತಂದರೆ ಕಡೇ ಪಕ್ಷ 60 ದಿನ ಒಳಗಡೆ ಜಜ್ಮೆಂಟ್ ಆಗಲೇಬೇಕು. So after the hearing, normally it should be within 30 days. If it is not possible or practicable, then within 60 days it has to be pronounced, and for that the due notice has to be given to the pleaders. Here we can look into one important case, Anil Rai versus State of Bihar. That is in 2001, All India Reporter 2001, Supreme Court 3173. In this case, what has happened is the hearing was over, and it was postponed to a future date. Now this date went on postponing again and again. The dates were given. Finally it went on for 2 years, and the High Court pronounced the judgment after 2 years. After this was after the hearing the arguments. After the arguments also it was just postponed and judgment was not done. This was a question which was deprecated by the judges. The judges said that it is not a proper procedure when the civil procedure code says clearly that 60 days. Why 60 days? Because the object is that you should get the relief immediately. Secondly, if they have to go in appeal, the cases have already, if it is if the judgment is delayed, what happens? The facts have changed. There are so many things which may happen, and which will not allow the party to get his relief at all. Judgment pronounce ಮಾಡಿಲ್ಲ ಅಂತಂದರೆ, ನೀವು ಹಿಯರಿಂಗ್ ಆಗಿ ಜಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಅದರಲ್ಲಿ ಎಷ್ಟೊಂದು ಸಂಗತಿಗಳಾಗ್ಬೋದು. ಅದಕ್ಕೆ ಈ ಪರ್ಪಸ್ ಆಫ್ ಕಮಿಂಗ್ ಟು ದ ಕೋರ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ನಾಟ್ ಸರ್ವ್ಡ್ if the judgment is not pronounced earlier. And so in this case the court has the Supreme Court has said that when it is stated that it should be within 60 days, it must be pronounced within that time according to the CPC. Then what is the method of pronouncing the judgment? For example, whether he has to read out the whole thing, whether the judge has to read out the whole, because you know that judgments consist of several pages. So the thing is, in the judgment, what are the things? According to that, there are findings on each issue, because the issue has been framed by the court. So on every issue there will be a finding in the judgment. So it shall be sufficient to just pronounce the finding on each issue, and not it is not needed to read the whole judgment at all. Complete judgment ಓದೋದು ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಆದರೆ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಗೆ ಸ್ಪೆಷಲಿ ಎಂಪವರ್ ಮಾಡಿದರೆ, suppose the High Court judge is given special power to pronounce by dictation in open court, we see in the High Courts that the whole judgment will be pronounced sitting in the court, open court, dictating it to the shorthand writer or to the typist or to the and now it is a computer. So it is dictated there itself. So that can happen when the High Court judge is specially empowered. Then where it is pronounced by dictation in open court, then what happens? As soon as he dictates, the transcription of that judgment will be signed immediately there itself. ಅಲ್ಲೇನೆ ಅದನ್ನು ಅವರು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತಾರೆ, ಅಲ್ಲೇ ಅವರು ಸೈನ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ ಏನಾದರೂ ಕರೆಕ್ಷನ್ಸು ಗ್ರಾಮಟಿಕಲಿ ಮಾಡಬೇಕಂದ್ರೆ ಮಾಡಿಬಿಟ್ಟು ಅದನ್ನು ಡೇಟ್ ಹಾಕಿ ಸೈನ್ ಮಾಡಿ ಅದನ್ನು ರೆಕಾರ್ಡ್ ಅಂತ ಇದಾಗುತ್ತೆ, ನಿಶ್ಚಿತ ಆಗುತ್ತೆ. ಸೊ ಇಟ್ ಬಿಕಮ್ಸ್ ಅ ರೆಕಾರ್ಡ್ ಆಸ್ ಸೂನ್ ಆಸ್ ಹಿ ಟೇಕ್ಸ್ ದಟ್. ಸೊ ತಕ್ಷಣವೇ ಅವರು ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಆಗಬೇಕು, ಅಂದರೆ ಅವರು ಕಾಪಿ ತೊಗೊಂಡು ಕೊಡಬೇಕು ಜಡ್ಜ್ಗೆ, ಅಲ್ಲೇ ಅವರು ಸೈನ್ ಮಾಡಬೇಕು. ದಟ್ ಈಸ್ ದ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ ರೂಲ್ 1 sub rule 3. Then there are some instances where a judge is transferred, or a judge is he dies, and the next judge who comes, that is a successor, he shall pronounce a judgment. What happens? Suppose he writes the judgment and he signs the judgment, or he writes the judgment and does not sign the judgment, and at that time he is transferred or he dies. If he is transferred, of course he can complete that, then he can go, if it is his wish, of course. So whether he has to look into what is the details of the judgment. So if it is not possible, he may just write the judgment and he may not sign it. So in such cases, the judge who comes afterwards, he can sign or he can pronounce a judgment which has written but not pronounced by his predecessor. ಅದು ಮುಂಚೆ ಯಾರು ಜಡ್ಜ್ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ ಅವರು ಟ್ರಾನ್ಸ್ಫರ್ ಆದರೆ ಅಥವಾ ಡೆತ್ ಆದರೆ ನಂತರ ಬಂದಿರುವಂಥ ಜಡ್ಜ್ನ ಈ ರೈಟ್ ಇದೆ, ಅವರ ಆ ಜಡ್ಜ್ಮೆಂಟನ್ನು ಪ್ರೊನೌನ್ಸ್ ಮಾಡುವಂಥ ಅವ್ರಿಗೆ ಅಧಿಕಾರ ಇದೆ ರೂಲ್ 2 ಪ್ರಕಾರ. ರೂಲ್ 3 ಪ್ರಕಾರ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದ ಮೇಲೆ ಅದನ್ನು ಚೇಂಜಸ್ ಮಾಡ್ಬೋದಾ? ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್ ಆಗೋಗಿದೆ, one judgment is already signed by the judge in open court and it is dated and pronounced also. So after that judgment remains as conclusive judgment. This is very important. You cannot change, you cannot add anything to the judgment. Nobody can add, not even that single judge. He cannot add. Or if it there is only one procedure, that is section 152. Under 152, if there are grammatical mistakes, or if there are typing mistakes or spelling mistakes, or anything relating to maybe it is misunderstood in some form. So in such cases, then it can be the same judge can alter the judgment. You have to file an application under section 52 and then he will change that particular word. Then, or on review, suppose you can file it on to the same court on review. You can go for review, or you can just directly file a application under section 152. ಅದನ್ನ ಮಾಡಿದಾಗ 152 ಪ್ರಕಾರ ಒಂದು ಅರ್ಜಿ ಮಾಡಿದಾಗ ಅವರು ಅದನ್ನ ನೋಡಿ ಏನು ತಪ್ಪಾಗಿದೆ ಅದರಲ್ಲಿ ಅದು ಚೇಂಜ್ ಮಾಡಬಹುದು. In one of my own cases, the motor vehicles case accident, motor vehicles accident case ಇತ್ತು. ಅದರಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಬೇಕಾಗಿತ್ತು. ಸೊ ಹಿ ಗಾಟ್ ಎ ಕಾಂಪೆನ್ಸೇಷನ್ ಫಾರ್ ದ ಇಂಜುರಿ ಇನ್ ದ ಆಕ್ಸಿಡೆಂಟ್. ಇಂಜುರಿ ಆಗಿದ್ದಕ್ಕೆ ಅವ್ರಿಗೆ ಕಾಂಪೆನ್ಸೇಷನ್ ಸಿಕ್ತು. ಆ ಕಾಂಪೆನ್ಸೇಷನ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡುವಾಗ ಅರಿಯರ್ಸ್ ಆಫ್ ವಾಟ್ ಎವರ್ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ದ ಕೇಸ್ ಟಿಲ್ ದಟ್ ಡೇಟ್, ಇಟ್ ವಾಸ್ ನಿಯರ್ಲಿ ಅಬೌಟ್ 3 to 4 years. ಸೊ ಅದನ್ನ ಟಿಲ್ ದಟ್ ಡೇಟ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಅದನ್ನ ಇಷ್ಟು ಅಮೌಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಟೋಟಲ್ ಹಾಕಿದ್ರು. So when that was calculated by the court itself. Court means of course they have the person who will calculate and he will give the amount. So it was calculated and then it was already pronounced. Then at that time, even as a advocate, it is our duty to check that at that time, but it was not checked by mistake, even because it was a huge amount. ಅದನ್ನು ನಿಯರ್ಲಿ ಒಂದು 50 lakhs ಇತ್ತು. ಕೆಲವು ಇದನ್ನು 50 lakhs ಆ್ಯಂಡ್ ಸಮ್ ಅಮೌಂಟ್ ಇತ್ತು. ಸೊ ಅದನ್ನು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ದೇನೆ ಹಾಗೆ ನಾವು ತಗೊಂಡ್ವಿ, ಅದನ್ನು ಕಾಪಿನೂ ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ. ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ ಮೇಲೆ ನಮಗೆ ಇನ್ನೊಂದು ಸತಿ ನಾವು ಬಿಫೋರ್ ದ್ಯಾಟ್ ಓನ್ಲಿ, ಬಿಫೋರ್ ಗೆಟಿಂಗ್ ದಟ್ ಕಾಪಿ ವಿ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್ ಸೆಪ್ರೇಟ್ಲಿ. ನಾವು ಸೆಪ್ರೇಟ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡುವಾಗ ನಮಗೆ ಗೊತ್ತಾಯಿತು ದೇರ್ ಈಸ್ ಸಮ್ ಮಿಸ್ಟೇಕ್ ಇನ್ ದ ಕ್ಯಾಲ್ಕುಲೇಷನ್. And she was getting 8,000 rupees less according to the calculation. So ಇದು ಏನಂದ್ರೆ ಇದು grammatical mistake ಇಲ್ಲ, spelling mistake ಇಲ್ಲ. It is something which is calculated wrongly by the court itself. So ಅದರಿಂದ we filed an application immediately under section 152. 152 ಪ್ರಕಾರ ಅದನ್ನು ಚೇಂಜಸ್ ಮಾಡೋ ಪವರ್ ಕೋರ್ಟ್ಗೆ ಇದೆ. ಕೋರ್ಟ್ ಮತ್ತೆ ಅದನ್ನು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ತು, ಆಮೇಲೆ ಮಾಡಿ ಅದನ್ನು ಚೇಂಜ್ ಮಾಡಿದರು. ಅಂದರೆ ಒಂದು ನಂಬರ್, ಒಂದು ಫಿಗರ್ ಅಥವಾ ಒಂದು ಅಲ್ಫಾಬೆಟ್, ಯಾವುದಾದ್ರೂ ಒಂದು ಪದ, ಅದನ್ನು ಸಹ ಚೇಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಕೋರ್ಟ್. ಏನು ಮಾಡಬೇಕು ಕೋರ್ಟ್? ಅದು ಜಜ್ಮೆಂಟ್ ಟ್ರಾನ್ಸ್ಕ್ರೈಬ್ ಆದ ತಕ್ಷಣವೇ ಕೋರ್ಟ್ ಅದನ್ನು ನೋಡಿ ಅಲ್ಲಿನೇ ಚೆಕ್ ಮಾಡಬೇಕು. ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಬೇಕು. ಅಕಸ್ಮಾತ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡೋಕ್ಕಾಗಲಿಲ್ಲ ಅಂದರೆ ಅವರು ಟೈಮ್ ತಗೋಬೋದು, ಚೆಕ್ ಮಾಡಿ ಅವ್ರು ಹೇಳ್ಬೋದು ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ. ಆದರೆ ಅವ್ರು ಜಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್ ಮಾಡಲ್ಲ. ಪ್ರೊನೌನ್ಸ್ ಯಾವಾಗ ಮಾಡ್ತಾರೆ? ಪೂರ್ತಿ ಅದನ್ನು ನೋಡಿ ಚೆಕ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಯಾವುದೇ ಡಿಫ್ರೆನ್ಸ್ ಇಲ್ಲ, ಯಾವುದೇ ಮಿಸ್ಟೇಕ್ ಇಲ್ಲ ಅಂತ ಅವರು ಗಮನಿಸಿ ನಂತರ ಅವರು ಸೈನ್ ಮಾಡಿ ಡೇಟ್ ಮಾಡಿ ಆನ್ ದಿಸ್ ಡೇಟ್ pronounced by on this date ಅಂತ ಹೇಳಿ ಅವತ್ತಿನ ದಿನ ಅವರು ಜಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್ ಮಾಡಬೇಕು. ದಟ್ ಈಸ್ ದ ಪ್ರೊಸೀಜರ್ ಆಫ್ ದ ಜಜ್ಮೆಂಟ್. ಆಫ್ಟರ್ ದಟ್ ಇಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಚೇಂಜ್ ಅಂಡರ್ ರೂಲ್ 3. Okay, so these are the normal things which we observe in the courts, that of course these are very compulsory mandatory rules which have to be followed. Then there are judgments of small cause courts under rule 4 sub rule 1. There, what are the contents of judgments of small cause courts? So in the court of small causes there should be only the points for determination and the decision thereon. ಮತ್ತೆ ಡೀಟೇಲ್ಸ್ ಕೊಡೋದು ಬೇಕಾಗಿಲ್ಲ. ಯಾವ ಪಾಯಿಂಟ್ಸ್ ಅಲ್ಲಿ ನಿರ್ಣಯ ತಗೋಬೇಕು, ಪ್ರತ್ಯೇಕ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಏನೇನು ನಿರ್ಣಯ ತಗೊಂಡಿದ್ದಾರೆ ಅಷ್ಟು ಕೊಟ್ಟರೆ ಸಾಕು. ದಟ್ ಈಸ್ ದ ಓನ್ಲಿ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ ದ ಜಜ್ಮೆಂಟ್. ವಿನ್ ಅದರ್ ಕೋರ್ಟ್ಸ್ ದ ಜಜ್ಮೆಂಟ್ ಶುಡ್ ಕಂಟೈನ್ ದೀಸ್ 4 ಥಿಂಗ್ಸ್. ಯಾವುದೇ ಕೋರ್ಟಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಆದರೆ ಈ 4 ಅಂಶಗಳು ಇರಬೇಕು. 1 is a concise statement of the case. In the starting of the judgment there will be the case is in brief, that case will be stated. ಆ ಕೇಸ್ ಏನಿದೆ ಅಂತ ಒಂದು ಶಾರ್ಟ್ ಅಲ್ಲಿ ಅದು ಮೇಲ್ಗಡೆ ಅದನ್ನ ಬರೆದಿರಬೇಕು. ಒಂದು ಇದರಲ್ಲಿ ಒಂದು ಹೇಳಿಕೆ, ಕೋರ್ಟಿನ ಹೇಳಿಕೆ ಪ್ರಕಾರ ಅದನ್ನ ಹೇಳಬೇಕು, ಈ ತರ ಇದೆ ಅಂತ. ಆಮೇಲೆ ದ ಪಾಯಿಂಟ್ಸ್ ಫಾರ್ ಡಿಟರ್ಮಿನೇಷನ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪುಟ್ ಫೋರ್ತ್. ಸೊ ಏನು ಇಶ್ಯೂಸ್ ಮಾಡಿದ್ರೋ ಆ ಇಶ್ಯೂಸ್ ಪ್ರಕಾರ ಈ ಪಾಯಿಂಟ್ಸ್ ನಮ್ಮ ಮುಂದೆ ಇದೆ, ನಾವು ಇದನ್ನ ನಿರ್ಣಯ ತಗೋಬೇಕು ಅಂತ ಹೇಳಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 1, ಪಾಯಿಂಟ್ ನಂಬರ್ 2, ಪಾಯಿಂಟ್ ನಂಬರ್ 3, ಪಾಯಿಂಟ್ ನಂಬರ್ 4 ಆ ಥರ ಬರಬೇಕು. ಪ್ರತ್ಯೇಕ ಪಾಯಿಂಟ್ ಮೇಲೆ ಅವರ ಡಿಸಿಷನ್ಸ್ ಕೊಡಬೇಕು. ದ ಡಿಸಿಷನ್ ಆನ್ ಪಾಯಿಂಟ್ ನಂಬರ್ 1 ಅಂತ ಹೇಳಿ ವಿತ್ ಕಾರಣ, ದ ರೀಸನ್ಸ್ ಫಾರ್ ಸಚ್ ಡಿಸಿಷನ್, ಪ್ರತ್ಯೇಕ ಇದರಲ್ಲಿ ಕಾರಣ ಕೊಟ್ಟು ವಿತ್ ರೀಸನ್ ಎವ್ರಿ ಪಾಯಿಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಎಕ್ಸ್ಪ್ಲೇನ್ಡ್ ಬೈ ದ ಜಡ್ಜ್. He has to give the reason why he has come to that particular decision. These 4 things are what you call as the 4 essentials of a particular judgment. If that is not there, it is not a proper judgment. This is important. This is rule 4 sub rule 2. Coming to rule number 5. Now every issue there has to be a finding. Okay, as we said, so for every issue there has to be finding. But suppose, see, wherever in cases, in all suits issues are not framed, questions are framed or only points for determination are stated. But in suits where issues have been framed, every separate issue has to be looked into by the court, and the court should record its finding on that. So on this issue, this is the reason why I have come to this particular decision. But suppose for the whole decision of the suit, one finding on number of issues, say for example you can answer issue number 2 and 3 together also. So he can put it as issue number 2 and 3, it is decided in the negative or in the positive, reason is this. So he can, even on one or more issues also, he can the judge can write the reason. So this, in one case, State of Maharashtra versus Ramdas Srinivas Naik, I think you know about this case. We have studied about this in the constitution also, where the question was whether the sanction of the governor which is obtained when a chief minister has to be sued in the court. If you have to sue a chief minister in the court, then the sanction of the governor has to obtain. In this case, the governor gives his sanction, and after that it is that there was a charges of corruption against the chief minister Antule of Maharashtra. That is the case which we have discussed in several in administrative law, in constitution also, from several angles. Now for us the question is that whether what is stated in that particular case, the finding has been given by the court. Okay, once the finding is given by the court, can it be questioned later on? Now when he goes in appeal, this was a special appeal to the Supreme Court under article 136 of the constitution. Once sate finding kottidare, finding alli findings kottu reasons ಕೊಡ್ತಾರೆ ಕೋರ್ಟ್. ಫೈಂಡಿಂಗ್ ಅಂದ್ರೆ ಏನು, ಎವಿಡೆನ್ಸ್ ತಗೊಂಡಾಗ ಏನೋ ನಾವು ಅದರಲ್ಲಿ ಸಂಗತಿಗಳನ್ನ ಕೇಳಿದಾಗ ಆ ಸಂಗತಿಗಳ ಬಗ್ಗೆ ನೋಡುವಾಗ ಈ ಕನ್ಕ್ಲೂಷನ್ ಬಂದಿದೆ ಅಂದ್ರೆ ಈ ತರ ಸಂಗತಿಗಳಿದೆ, ಅದರಿಂದ ನಾವು ಈ ತರ ನಾವು ಒಂದು ಡಿಸಿಷನ್ ಕೊಡ್ತಾ ಇದ್ವಿ, ನಿರ್ಣಯ ಕೊಡ್ತಾ ಇದ್ವಿ. ಸಪೋಸ್ ಇನ್ ದಿಸ್ ಕೇಸ್ the finding was recorded and the finding showed the facts. In the high court has given it. So in the Supreme Court he goes in special appeal, that is R.S. Naik, he goes in special appeal and says that the finding which is given in the lower court itself is not proper, and the facts which are stated are not proper, and therefore it should be changed. And the court has a special power under 136, and the court has to look into this appeal and decide. Now in this case, the Supreme Court says that once the statement of fact is stated at the hearing, he comes to know, the judge comes to know about the facts in the hearing. When the hearing vicharane adaga court ge gottagutte facts enu anta. Once he comes to the hearing, once he records the fact, that fact should be checked by the advocates at that time only. ನೀವು ಫ್ಯಾಕ್ಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದಾಗ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಸೊ ವಾಟ್ ಎವರ್ ಹಿ ಹ್ಯಾಸ್ ಕಮ್ ಟು ಅಂಡ್ ಡಿಸಿಷನ್ ವಿಲ್ ಬಿ ನೋನ್. ಸೊ ವಾಟ್ ಹಿ ಹ್ಯಾಸ್ ರೆಕಾರ್ಡೆಡ್, ಸಿ ವೆದರ್ ದಿಸ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪೆಂಡ್ in case of when the case was before the court, even after at the time of recording its finding also, if there is any what you call as a misinterpretation of the facts, it has to be brought to the notice of the court there and then. So the court may again ask for evidence or may ask for any other further facts and then come to the finding properly. ಓಕೆ, ಕೋರ್ಟ್ಗೆ ಮಿಸ್ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆಗಿದೆ, ಮಿಸ್ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಗಿದೆ ಅಂದರೆ ಅಲ್ಲಿ ನೀವು ಕ್ಲಾರಿಫೈ ಮಾಡಬೇಕು. ಹಿ ಗೋಸ್ ಇನ್ ಅಪೀಲ್ ವೆದರ್ ದ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅ ರೈಟ್ ಟು ಚೇಂಜ್ ಇಟ್. ಸೊ ದೇರ್ ದ ಕೋರ್ಟ್ ಸೇಸ್ ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಫೈಂಡಿಂಗ್ ಬೈ ಒನ್ ಜಡ್ಜ್ ಕೆನಾಟ್ ಬಿ ಕ್ವೆಶ್ಚನ್ ಇಫ್ ಇಟ್ ಈಸ್ ರಿಲೇಟಿಂಗ್ ಟು ಫ್ಯಾಕ್ಟ್ಸ್. ಇಫ್ ಇಟ್ ಈಸ್ ಫೈಂಡಿಂಗ್ ರಿಲೇಟಿಂಗ್ ಟು ಪಾಯಿಂಟ್ ಆಫ್ ಲಾ, then it can be looked into in the appeal. ಈ ಲಾನ ಸರಿಯಾಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಜಡ್ಜ್, ಕಾನೂನು ಈ ತರ ಇದೆ ಅಂತ ಹೇಳಿದಾಗ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಇರುವಾಗ ಮಾಡಬಹುದು. ಫ್ಯಾಕ್ಟ್ಸ್ ಒನ್ಸ್ ಸ್ಟೇಟೆಡ್ ಕೆನಾಟ್ ಬಿ ಕಾಂಟ್ರಾಡಿಕ್ಟೆಡ್ ಬೈ ಅಫಿಡವಿಟ್ ಆರ್ ಎನಿ ಅದರ್ ಎವಿಡೆನ್ಸ್ ಆಲ್ಸೋ. ಬೇರೆ ಎವಿಡೆನ್ಸು ಕೊಡೋಕ್ಕಾಗಲ್ಲ, ಅಫಿಡವಿಟ್ ಕೊಡೋಕ್ಕಾಗಲ್ಲ. ಈ ಫ್ಯಾಕ್ಟ್ ಇಲ್ಲ ಅಂತ ಒಂದ್ಸತಿ ಫೈಂಡಿಂಗ್ ಬಂತು ಅಂತಂದ್ರೆ ಆ ಫೈಂಡಿಂಗ್ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳುತ್ತೆ ಈ ಕೇಸಲ್ಲಿ. So this is very important. So when the finding has given by the court, that finding is on facts, that cannot be changed. Okay. Now suppose in some cases the pleaders are not there, parties are not represented by pleaders. There are certain cases where you need not have a pleader, the parties themselves can represent. So when the court, of course the CPC says that either through the parties or through somebody who is authorized or through the pleaders. So when it is not represented by pleaders, suppose the judgment is pronounced and that judgment is subject to appeal. ಅದು ಅಪೀಲ್ಗೆ ಹೋಗ್ಬೋದು ಅಂತ ಜಜ್ಮೆಂಟ್ ಇದ್ರೆ, ಅಂತ ಸಮಯದಲ್ಲಿ ಪಾರ್ಟೀಸ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ಅಪೀಲ್ ಎಲ್ಲಿ ಹೋಗಬೇಕು, ಯಾವ ಕೋರ್ಟ್ಗೆ ಹೋಗಬೇಕು, ಏನು ಲಿಮಿಟೇಷನ್ ಇದೆ ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ಜಜ್ಮೆಂಟ್ಸ್ ಮಾಡೋ ಸಮಯದಲ್ಲಿ ಪಾರ್ಟೀಸ್ಗೆ ಕೋರ್ಟ್ ಮಾಹಿತಿ ಕೊಡಬೇಕು. ಇಂಥ ಕೋರ್ಟಲ್ಲಿ ಅಪೀಲ್ ಇದೆ, ನೀವು ಫೈಲ್ ಮಾಡ್ಬೋದು, ಮತ್ತು ಲಿಮಿಟೇಷನ್ ಇಷ್ಟಿದೆ ಫೈಲ್ ಮಾಡೋಕ್ಕೆ, ಆ ಕಾಲ ಪರಿಮಿತಿ ಒಳಗೆ ನೀವು ಹಾಕಬೇಕು, ಮತ್ತು ಏನೇನೋ ಇನ್ಫಾರ್ಮೇಷನ್ ಇದೆ ಅದನ್ನೆಲ್ಲ ರೆಕಾರ್ಡಲ್ಲಿ ಇಡಬೇಕು, ಮತ್ತು ಕೋರ್ಟ್ಗೆ ನಾವು ಈ ಥರ ಇನ್ಫಾರ್ಮೇಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತಾನೂ ಬರೀಬೇಕು. ಸೊ ದ ಕೋರ್ಟ್ ವೆನ್ ಇಟ್ಸ್ ಪ್ರೊನೌನ್ಸಸ್ ಇಟ್ಸ್ ಜಜ್ಮೆಂಟ್, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಇನ್ಫಾರ್ಮ್ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ದ ಪಾರ್ಟೀಸ್ that this is the place which court you have to go in appeal. Secondly, what is the time within which you can go in appeal, and then whatever has been given information to the parties has to be put on record. That is the requirement of rule 5A. Then rule 6B speaks about furnishing the copy of the judgment. Okay, 6 and 6A comes to decree. 6B speaks about a copy of judgment. Whenever the judgment is pronounced, the copy should be given immediately after the pronouncement of the judgment. It should be made available to the parties. Available means it is not that it is not taken as if you have to take a Xerox copy or you have to take a certified copy immediately anta artha alla. Copy should be available ಅಂದ್ರೆ ತಕ್ಷಣ ನೀವು ನೋಡಬಹುದು. ಅದನ್ನ ಕೋರ್ಟಲ್ಲಿ ಅವರು ಜಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್ ಮಾಡಿದ ಮೇಲೆ ನಿಮಗೆ ತೋರಿಸಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಿ ಆ ಜಜ್ಮೆಂಟ್ ಅವೈಲಬಲ್ ಇರಬೇಕು. ಪಾರ್ಟೀಸ್ ಇಬ್ರು ಪಾರ್ಟೀಸ್ ಅದನ್ನ ನೋಡಕ್ಕೆ ಅವ್ರಿಗೆ ಪವರ್ಸ್ ಇದೆ, ಅವ್ರಿಗೆ ತಕ್ಷಣ ನೋಡ್ಬೋದು. ಆ್ಯಂಡ್ ಆಫ್ಟರ್ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ದ ಜಜ್ಮೆಂಟ್ ಫಾರ್ ಪ್ರೆಫರಿಂಗ್ ಅನ್ ಅಪೀಲ್ ಅಂಡ್ ಪೇಮೆಂಟ್ ಆಫ್ ಚಾರ್ಜಸ್ ಆಸ್ ಪರ್ ದ ರೂಲ್ಸ್ ಆಫ್ ದ ಹೈಕೋರ್ಟ್, ನೀವು ಏನು ಅಪೀಲ್ಗೆ ಹೋಗಬೇಕು ಅದ್ರ ಪ್ರಕಾರ ಕಾಪಿಗೆ ಅಪ್ಲೈ ಮಾಡೋದು, ಪೇಮೆಂಟ್ ಆಫ್ ಚಾರ್ಜಸ್ ಕೊಡೋದು, ಇವೆಲ್ಲ ತಕ್ಷಣನೇ ಮಾಡಬಹುದು. ಅದಕ್ಕೆ ಕಾಪಿ ಅವ್ರಿಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಅವೈಲಬಲ್ ಮಾಡಬೇಕು ಅಂತ ಇರುತ್ತೆ. Then there are some cases where we have discussed how the court has to, as I said, they have to give reasons. So how the reasons have to be stated, whether that reason should be, it is compulsory to be stated. Of course, we have studied in several cases before in the constitution or when we are discussing administrative law, that a recording of reasons is part of principles of natural justice. We said that it is part of principles of natural justice. We are bound to know the reason for which that thing has been imposed upon us, right? So the person has to know he has an opportunity to be heard, and therefore he also needs to know the reasons for the decision. So if the decision does not give the reasons, proper reasons, then the principles of natural justice are violated, and the people who are adversely affected by that decision are not getting the protection. Therefore, recording reasons is the main protection. They can go to appeal on the basis of that reasons. Judgment alli reason illa andre appellate court ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯಾವ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಆ ರೀಸನ್ ಆ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಗೊತ್ತಾಗಲ್ಲ. So in the judgment, the court should deal with all submissions and arguments. ಏನೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ತಾರೆ, ಪಾರ್ಟೀಸ್ ಏನೇನು ಹೇಳ್ತಾರೆ, ಆ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಗಮನಕ್ಕೆ ತಗೊಂಡು ಆ ಸಬ್ಮಿಷನ್ಸ್ ಮೇಲೆ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಪಾಸ್ ಮಾಡಬೇಕು. ಅಕಸ್ಮಾತ್ ಅದನ್ನ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ಆ ಜಜ್ಮೆಂಟ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಇನ್ ಒನ್ ಕೇಸ್, ಬಾಲಕೃಷ್ಣ ಚತುರ್ಭುಜ್ ಠಾಕರ್ ವರ್ಸಸ್ ದೇವಾಬೈ. ಇನ್ ದಿಸ್ ಕೇಸ್ ಇಟ್ ವಾಸ್ ಎ ಸೂಟ್ ಫಾರ್ ಪೊಸೆಷನ್ ಫಾರ್ ರಿಡೆಂಪ್ಷನ್ ಆಫ್ ಮಾರ್ಗೇಜ್. ದಿಸ್ ಇಸ್ ಗುಜರಾತ್ ಹೈಕೋರ್ಟ್ ಡಿಸಿಷನ್. ಅಲ್ಲಿ ಲಾಯರ್ಸ್ ಕೆಲವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡುವಾಗ ಕೆಲವು ಕೇಸ್ ಲಾಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ. So when they are discussing when they are arguing in this case, the lawyer speaks about some case laws of the Supreme Court, and this is the High Court. So it is binding on the High Court. While giving the judgment, those judgments or those case laws are not referred to by the High Court. High Court does not mention that, and the decision is pronounced. They go in appeal to the Supreme Court on that ground that whatever we have submitted to the court has not been taken consideration by the court. In this case, the court says that, Supreme Court says that it is mandatory for the courts to look into all the things which have been submitted. They cannot say that ಈ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡಿಲ್ಲ ಅಥವಾ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳುವಾಗ ಇಂಥ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡಿದ್ದೀವಿ. ದೇ ಹ್ಯಾವ್ ಎ ರಿಟನ್, ಅಫ್ಕೋರ್ಸ್ ಓರಲ್ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಅವರು ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ ಅಂದರೆ ದೆರ್ ಇಸ್ ನೋ ಪ್ರೂಫ್. ನೀವು ಹಾಗೆ ಹೋಗ್ಬಿಟ್ಟು ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೆ ಅಂತ ಹೇಳೋಕ್ಕಾಗಲ್ಲ. ಬಟ್ ನೀವು ರೈಟಿಂಗಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ, ಅದ್ರ ಸಪೋರ್ಟ್ ಆಗಿ ನೀವು ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ, then there is a proof that you have submitted these things. If the court doesn't take it into consideration in appeal, the court can look into that matter. So ಅದರಲ್ಲಿ court should deal with all submissions and arguments in the judgment ಅಂತ ಹೇಳಿ ಇದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಬಾಲಕೃಷ್ಣ ಚತುರ್ಭುಜ್ ಕೇಸಲ್ಲಿ. So this is how the court should look into everything what has been stated by the parties, and then it has to record the reasons for the support of the decision. It may take that argument in a favorable as a favorable thing for the decision, or against that also, whatever it is, or it may not it may distinguish that particular case law and say that that does not apply in this case, but that has to be stated. Just because the court has reached a decision, it cannot just neglect what is stated by the advocates. Whatever they have stated, it has to be looked into by the court. That is important. Okay. So when there is a case before the court, when the hearing is going on before the court sits there and looks into all the developments which is taking place, that is the witnesses, their demeanor, the facts which come out as a result of the evidence being presented before the court. What are the facts which are stated before the court? All these things, after looking into it, then the court pronounces its decision. So therefore, at the end, when the argument is done also, those arguments have to be looked into by the court. That is the decision in this case. Then now we come to the next stage, that is the decree. Now after the judgment, decree is passed. Now what is the importance of the decree and what is the importance of the judgment? Judgment gives the reasons. Yes, judgment speaks about all the points and it gives the reasons for the judgment. But decree is a main what you call as a operative part of the judgment. It is an essential part of the ultimate outcome. Therefore, it is something which is important, which is required, which is indispensable. So the decree is required for an appeal. Appeal lies against a decree, not against a judgment. So without a decree, appeal cannot be put in motion. You cannot start the appeal. Of course, if if it is late for you to obtain the copy of the decree, because decree is drawn up later, first the judgment comes in, then in that case you can file the appeal pending the copy of the decree with the copy of the judgment only. But decree is required. Without the decree you cannot go. After the decree is pronounced only, it is you can give the copy, and that the appeal will go according to, appeal will be taken up according to the decree only. Then preparation of decree within 15 days from the date of which the judgment is pronounced. As far as possible, before that also it can be done, within 15 days, 15 ದಿನ ಒಳಗೆ ಜಜ್ಮೆಂಟ್ ಆದ ತಕ್ಷಣ ಡಿಗ್ರಿ ಆಗಬೇಕು. ಅಕಸ್ಮಾತ್ ಡಿಗ್ರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಕಾಪಿ ಅಲ್ಲದೇನೆ ಅಪೀಲ್ಗೆ ಹೋಗಬಹುದು. ದಿಸ್ ಇಸ್ ರೂಲ್ 6A. What is the form of the decree? According to appendix 6 to the first schedule, with necessary variations, the decree can be made. That is a particular form is there. Rule 6 ಹೇಳುತ್ತೆ contents of the decree. ಡಿಕ್ರಿ ನಲ್ಲಿ ಏನೇನು ಇರಬೇಕು? ಡಿಕ್ರಿ ನಲ್ಲಿ first number of the suit ಇರಬೇಕು. First the number of the suit, then the name and description of the parties and the registered addresses. Okay, because it is necessary for execution, you need to give their registered addresses. Then the particulars of the claim, what are their claims, the particulars have to be stated in the decree. Then for those claim, what is the relief granted. Okay, then the cost which is incurred in the suit, and who will pay those costs, in what proportions, whether the plaintiff pays, whether the defendant pays, who pays the cost, that has to be stated in the decree. And the date on which the judgment was pronounced will be stated, and then finally there should be a signature of the judge. These are the required essentials of a decree. If any of this is not there, you can again approach the same court to rectify that error. Okay, and a successor judge can sign a decree drawn up by his predecessor. Suppose a person as a judgment also, judgment ಒಬ್ರು ಸೈನ್ ಮಾಡ್ತಾರೆ, after that ಅವರು ಡೆತ್ ಆಗುತ್ತೆ ಅಥವಾ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತೆ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಸಕ್ಸೆಸರ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿದ್ವಿ. ಈ ಸೇಮ್ ವೇ, ಇಫ್ ಎ ಡಿಕ್ರಿ ಇಸ್ ಡ್ರಾನ್ ಅಪ್ ಅಂಡ್ ನಾಟ್ ಸೈನ್ಡ್ by the judge, the successor judge can sign a decree which is drawn up by his predecessor. Then rule number 9 to rule 19 in order 20 deals with decrees in special cases or different kinds of cases in which decrees are drawn. For that there are different requirements. Suppose it is a decree for recovery of immovable property. Under rule 9 it says that description of the property sufficient to identify should be there. The property should be stated in such a manner that the boundaries of the property, what are, if it is amenable to survey, city survey, and it is in the survey record, then that survey number is different from the actual address which is of the property. So we have to identify that. That has to be mentioned in the decree. The schedule, whatever we have given to the court, that has to be mentioned in the decree so that it can be enforced, the decree can be enforced. So in the court, when the decree is pronounced, you have to see whether this thing is stated in the decree. Okay, then coming to movable property, if it is a delivery of movable property, see there are two options in that case. A person, if he gets a decree for movable property and that movable property is not able to be given to him, then in an alternative he can accept money also. So of course, if it is not a specific relief act, under the specific relief act it is not for specific performance and he asks for that particular property only. Instead of that, if it is any movable property and he is able to accept the amount, then in that decree itself it has to be stated what is the alternative amount to be paid if the delivery is not possible. ಆ ಮೂವೇಬಲ್ ಪ್ರಾಪರ್ಟಿನ ಚಲ ಸ್ವತ್ತನ್ನ ಕೊಡಕ್ಕಾಗಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಬದಲಾಗಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡಬೇಕು ಅದನ್ನು ಡಿಕ್ರಿನಲ್ಲಿನೇ ಹೇಳಿರಬೇಕು. ರೂಲ್ 11 ಸೇಸ್ ಅಬೌಟ್ ಡಿಕ್ರಿ ಫಾರ್ ಪೇಮೆಂಟ್ ಆಫ್ ಮನಿ, ಹಣದ ಸಂದಾಯಕ್ಕೋಸ್ಕರ. ಸೊ ಈ ಡಿಕ್ರಿ ನಾನು ಇವಾಗಲೇ ಈ ಹಣ ನಾನು ಕೊಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಏನಾದರೂ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಹೇಳಿದಾಗ, ಅಥವಾ ಡಿಕ್ರಿ ಜಜ್ಮೆಂಟ್ ಡೆಟರ್ಗೆ ಕಷ್ಟ ಆಗಿದೆ ನಾನು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ಸಲ್ಲಿ ಪೇ ಮಾಡ್ತೀನಿ ಅಂತ ಅವ್ರೇನಾದರೂ ಅರ್ಜಿ ಕೊಟ್ಟಾಗ ಕೋರ್ಟ್ಗೆ, ಆ ಕೋರ್ಟ್ ಆ ಡಿಕ್ರಿನಲ್ಲಿ, ಅದು ಜಜ್ಮೆಂಟ್ ಟೈಮಲ್ಲಿನೇ ಆಗುತ್ತೆ, at the time of pronouncing the judgment itself they will have stated this thing. So the court may order that payment of decretal amount will be postponed or shall be made by installments ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಆರ್ ವಿದೌಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಅದು ಬರಬೇಕು. ಡಿಕ್ರಿ ಅಮೌಂಟ್ ಇದ್ದಾಗ ಅದರಲ್ಲಿ ಬಡ್ಡಿ ಇದೆಯಾ ಇಲ್ವಾ ಅದರಲ್ಲಿ, ಅಥವಾ ಎಷ್ಟು ಯಾವಾಗ ಪೇ ಮಾಡಬೇಕು, ವಿದಿನ್ ವಾಟ್ ಡೇ, ಅಥವಾ ಅದು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಮಾಡಬಹುದಾ, ಹಂತದಲ್ಲಿ ಕೊಡಬಹುದಾ, ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ರೂಲ್ 11. ದೆನ್ ಇಫ್ ದರ್ ಇಸ್ ಅ ಡಿಕ್ರಿ ಫಾರ್ ಪೊಸೆಷನ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆ್ಯಂಡ್ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್, ಮಧ್ಯಾವಧಿ ಲಾಭಗಳು ಮತ್ತು ಸ್ವಾಧೀನತೆಗೆ ಡಿಕ್ರಿ ಆಗಿದ್ರೆ ರೂಲ್ 12 ಹೇಳುತ್ತೆ, ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಪೊಸೆಷನ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ ಅದ್ರ ಬಗ್ಗೆ, ಆ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಏನಾದರೂ ಬಾಡಿಗೆ ಇದ್ರೆ ಅದು ಎಷ್ಟು ಬಾಡಿಗೆ ಇದೆ ಅದನ್ನ ಪ್ರಯರ್ ಟು ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ದ ಸೂಟ್ ಎಷ್ಟಿತ್ತು ಮುಂಚೆ, ಮತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಬೇಕು. ಅಥವಾ ಅದು ಹೇಳಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ವಿಚಾರಣೆಗೆ ಹೋಗಬೇಕು. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡೈರೆಕ್ಟೆಡ್ ಆಸ್ ಎ ಎನ್ಕ್ವೈರಿ ಆಸ್ ಟು ರೆಂಟ್. ಮಧ್ಯಾವಧಿ ಲಾಭಗಳಿದ್ರೆ ಅದನ್ನ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು. ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಸೂಟ್, ಇಫ್ ದೆರ್ ಆರ್ ರೆಂಟ್ಸ್ ಆರ್ ಇಫ್ ದೆರ್ ಇಸ್ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್, ದೆನ್ ಅನ್ ಎನ್ಕ್ವೈರಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಡೈರೆಕ್ಟೆಡ್ into future rent also, and also the earlier rent. Then final decree should be passed after that. So first ಒಂದು ಪ್ರಿಲಿಮಿನರಿ ಒಂದು ಜಜ್ಮೆಂಟ್ ಡಿಕ್ರಿ ಆಗುತ್ತೆ, ಅದಾದಮೇಲೆ ಫೈನಲ್ ಡಿಕ್ರಿನಲ್ಲಿ ರೆಂಟ್ ಮತ್ತು ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಬಂದಾಗ ಅದರ ಪ್ರಕಾರ ಅದು ಡಿಕ್ರಿನಲ್ಲಿ ಹೇಳಿರಬೇಕು. ಇಫ್ ದರ್ ಇಸ್ ಅ ಡಿಕ್ರಿ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಫಾರ್ ಸೇಲ್ ಆರ್ ಲೀಸ್ ಆಫ್ ಇಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ, ಯಾವುದೋ ಒಂದು ಸ್ಥಿರ ಸ್ವತ್ತನ್ನು ನಮ್ಮ ಓರಲ್ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಇದನ್ನು ಕೊಡಬೇಕು ಅಂತ ಡಿಕ್ರಿ ಆದರೆ, ಅಥವಾ ಸ್ವಾಧೀನತೆ ಕೊಡಬೇಕು, ಲೀಸ್ ಮಾಡೋಕ್ಕೆ ಅಥವಾ ಸೇಲ್ ಮಾಡೋಕ್ಕೆ ಏನಾದರೂ ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದ್ರ ಪ್ರಕಾರ ಆಗಬೇಕು ಅಂತ ಹೇಳಿದಾಗ, ದೆನ್ ವೇರ್ ದ ಡಿಕ್ರಿ ಈಸ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್ ಫಾರ್ ಸೇಲ್ ಆರ್ ಲೀಸ್, ದೆನ್ ಇಟ್ ಶುಡ್ ಬಿ ದ ಪರ್ಚೇಸ್ ಮನಿ should be paid by the purchaser or lessee. It will say that within what time that purchaser has to pay the payment, then that property can be sold or delivered to him. So wherever there is a specific performance of contract, then the amount which has to be paid according to that agreement will be decided, and that will be mentioned in the decree. Then after he gives the amount, pays the amount, then it will be take effect. Then decree in administrative suit, rule 13. Suppose a person files for a administration of the property or any accounts of the property, and it is decreed, then before passing the final decree there will be a preliminary decree wherein the account of the property will all be ordered to be taken. For that the court may appoint a commission also to of course the orders have to be has to show what is the amount which is due and what is the account which is done in the property, and the inquiry should be made. After that the final decree will be passed. So in certain cases immediately decree will not be passed finally, it will be preliminary only, then the final decree will be passed according to the preliminary inquiry. That is ದೆನ್ ಪ್ರಿಯೆಂಪ್ಷನ್ ಸೂಟ್ ಅಂದರೆ ಮೊದಲು ಕ್ರಯ ಮಾಡಬೇಕು ಅಂತ ಹಕ್ಕು ಇರೋ ಅಂಥ ವ್ಯಕ್ತಿ, ಯಾರು ಪರ್ಚೇಸ್ ಮಾಡೋಕ್ಕೆ ಮೊದಲು ಪರ್ಚೇಸ್ ಮಾಡೋಕ್ಕೆ ಯಾರಿಗೆ ರೈಟ್ ಇದೆ ಅಂದರೆ, ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಇದ್ದಾಗ ಎರಡು ಆಪ್ಷನ್ಸ್ ಇರುತ್ತೆ. ಅವನು ಮೊದಲು ಅಮೌಂಟ್ ಕೊಟ್ಟಿರ್ತಾನೆ, ಕೆಲವು ಸತಿ ಅವನು ಕೊಟ್ಟಿರಲ್ಲ. ಈಗ ಅಮೌಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದರೆ ಯಾರ ಪರವಾಗಿ ಪ್ರಿಯೆಂಪ್ಷನ್ ಆಗಿದೆಯೋ, ಡಿಕ್ರಿ ಆಗಿದೆಯೋ, on for whom the preemption has been granted, if he has paid money into the court and if he has not paid money into the court. If he has paid the money, then it will state the day or on or before when the purchase money shall be paid. If he has not paid, if he has paid, then immediately the defendant will be allowed to get the possession of the property. Adanna it has to be mentioned in the decree. If payment is not made, even after directing payment to be made, then the suit will be dismissed with costs. When there are rival claims to preemption, suppose there are two people, both are claiming preemption. The other, one person is saying that I need to be first considered, I have a prior right. Second says I have a prior right. Then the decree will be passed. When the decree is passed, in that decree you have to state, the judge has to state what is the proportion of the claim between those two people, how much claim will be taking effect. Suppose it is both claims are equal, both have equal claims to preemption, then equally that preemption's claim will take effect proportionately to that property. ನೋಡಿದಾಗ ಅದರ ಸಮಭಾಗದಲ್ಲಿ ಇಬ್ಬರಿಗೆ ಇದನ್ನು ಹಂಚಬೇಕು, ಪ್ರಿಯೆಂಪ್ಷನ್ಗೆ ಈಕ್ವಲ್ ರೈಟ್ಸ್ ಇದ್ದಾಗ. ಡಿಫ್ರೆಂಟ್ ರೈಟ್ಸ್ ಇದ್ದಾಗ, ಕೆಲವ್ರಿಗೆ ಮೊದಲು ರೈಟ್ ಇರುತ್ತೆ, ನಂತರ ಕೆಲವು ರೈಟ್ ಬರುತ್ತೆ, ಇವನ್ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಅವನಿಗೆ ರೈಟ್ ಬರುತ್ತೆ. ಸಪೋಸ್ ಒನ್ ಪರ್ಸನ್ ಹ್ಯಾಸ್ ನಾಟ್ ಪ್ರಿಎಂಪ್ಟೆಡ್, ದೆನ್ ದ ಸೆಕೆಂಡ್ ಪರ್ಸನ್ ವಿಲ್ ಗೆಟ್ ದ ರೈಟ್. ಇನ್ ಸಚ್ ಕೇಸಸ್, ಇಫ್ ದೇರ್ ಆರ್ ಡಿಫರೆಂಟ್ degrees, then unless the superior preemptor has failed to make payment, then the inferior preemptor cannot take the effect. So therefore, in the decree, it has to be stated that it is different in decree, and who has the first right, and if he fails to make payment, it has to be given to the other person, that is the inferior preemptor. That has to be mentioned in the decree itself. So equal rights ಇದೆಯಾ, ಪ್ರಯರ್ ರೈಟ್ಸ್ ಒಬ್ರಿಗೆ ಇದ್ದು ನಂತರ ಇನ್ನೊಬ್ರಿಗೆ ಇದೆಯಾ, ಅದನ್ನು ಡಿಕ್ರಿನಲ್ಲಿ ಹೇಳಿರಬೇಕು. ರೂಲ್ 14. ರೂಲ್ 15 ಸ್ಪೀಕ್ಸ್ ಅಬೌಟ್ ಡಿಸಲ್ಯೂಷನ್ ಆಫ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್. ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡಿಸಲ್ವ್ ಆದಾಗ, ಫೈನಲ್ ಡಿಕ್ರಿ ಆದಾಗ ಪ್ರಪೋರ್ಷನೇಟ್ ಶೇರ್ ಆಫ್ ಪಾರ್ಟೀಸ್ ಹೇಳಬೇಕು. ಪ್ರತ್ಯೇಕ ಪಾರ್ಟಿಗೆ ಎಷ್ಟು ಶೇರ್ ಬರುತ್ತೆ. ಸೊ ಇಟ್ ಹ್ಯಾಸ್ ಟು, ದ ಡಿಕ್ರಿ ಹ್ಯಾಸ್ ಟು ಶೋ the proportionate share of the parties, and it has to state the day on which the dissolution takes place, and at that time when the accounts have to be taken and other acts to be done. When the partnership dissolves, there are several things which happen. So the new accounts have to be prepared, and the first accounts, they have to be adjusted. So that for that all the dates have to be fixed and has to be mentioned in the decree itself. Then if it is an account for between a principal and agent, then before passing a final decree, it will pass a preliminary decree taking for the accounts. Then it will make an inquiry relating to the accounts between the principal and agent. After that, then a final decree will be passed according to Rule 16. Then if there is such a case relating to taking accounts, then the court will also in the decree give special directions as to how the accounts have to be taken. For example, if the book of account is there, then the court will say that will be taken as a prima facie evidence. So according to that, the books of account which has been already put before the court, then the truth of the matters will be taken, and on that basis the accounts will be directed. If they have to take objection, they can take objection later on. The liberty will be given to parties. That has to be mentioned in the decree itself, that the liberty also will be given to the parties. Parties na ಸ್ವಾತಂತ್ರ್ಯ ಕೊಡ್ತಾ ಇದೀವಿ, ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಬಹುದು ಅಂದ್ರೆ ಮಾಡಬಹುದು ಅಂತ ಡಿಕ್ರಿನಲ್ಲಿ ಹೇಳಿರಬೇಕು. ಮತ್ತೆ ಯಾವ ರೀತಿ ಅಕೌಂಟ್ಸ್ ತಗೋಬೇಕು ಅದರ ಬಗ್ಗೆ ಸ್ಪೆಷಲ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಬೇಕು. Then if it is a suit for partition and separate position of share, ಪಾರ್ಟಿಷನ್ಗೆ ವಿಭಾಗಣೆಗೆ ಸೂಟ್ ಇದ್ರೆ ಆ ಡಿಕ್ರಿನಲ್ಲಿ ಅಕಸ್ಮಾತ್ ಅದು ರೆವೆನ್ಯೂಸ್ ಕೊಡುವಂಥ ಪ್ರಾಪರ್ಟಿ ಇದ್ರೆ, ಭೂ ಸಂದಾಯ ಕೊಡುವಂಥ ಪ್ರಾಪರ್ಟಿ ಇದ್ರೆ, ಅದರಲ್ಲಿ ಯಾರು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಬೋದು ಅಂದರೆ ಅವ್ರ ರೈಟ್ ಕಲೆಕ್ಟರ್ಗೆ ಕೊಡಬೇಕು. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಡೈರೆಕ್ಟ್ ಇನ್ ದ ಡಿಕ್ರಿ ಇಟ್ ಸೆಲ್ಫ್. ಅದು ಎಲ್ಲ ಪಾರ್ಟೀಸ್ ರೈಟ್ಸ್ ಹೇಳಿ ಯಾರ್ಯಾರ್ದು ಅದರಲ್ಲಿ ಹಿತಾಸಕ್ತಿ ಇದೆ, all the parties' rights who are interested will be stated, and it will be made by the collector. That has to be stated in the decree. Then in other cases of immovable property, first a preliminary decree will be passed declaring the rights of the parties, and then afterwards necessary direction will be given for what has to be done, how it has to be decided, how meets and bounds division of the property will be made, and then a final decree will be passed in a suit for partition of property. If it is a set off or counter claim and it is allowed, then what amount is due to plaintiff, what amount is due to defendant. Set off ವಜಾವಟ್ಟು ಅಥವಾ ಕೌಂಟರ್ ಕ್ಲೇಮಿನ ಪ್ರಶ್ನೆ ಇದ್ದಾಗ, ಎದುರು ಕ್ಲೇಮ್ ಇದ್ದಾಗ ಎಷ್ಟು ಪ್ಲೇಂಟಿಫ್ಗೆ ಅಮೌಂಟ್ ಕೊಡಬೇಕು, ಎಷ್ಟು ಡಿಫೆಂಡೆಂಟ್ಗೆ ಅಮೌಂಟ್ ಡ್ಯೂ ಇದೆ, ಎರಡು ವಜಾವಟ್ಟು ಯಾವ ರೀತಿ ಮಾಡಿದ್ವಿ ಆ ಡೀಟೇಲ್ ಡಿಕ್ರಿನಲ್ಲಿ ಇರಬೇಕು. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಇನ್ ದ ಡಿಕ್ರಿ, ಆ್ಯಂಡ್ ವಿಚ್ ಎವರ್ ಈಸ್ ಅಪಿಯರಿಂಗ್ ಟು ಬಿ ಡ್ಯೂ ಟು ಎನಿ ಪಾರ್ಟಿ, ದಟ್ ಅಮೌಂಟ್ ರಿಕವರಿ ಮಾಡೋಕ್ಕೆ ಏನು ಮಾಡಬೇಕು ಅದನ್ನು ಡಿಕ್ರಿನಲ್ಲಿ ಸ್ಟೇಟ್ ಆಗಿರಬೇಕು. So these are the different things which we discussed today. First of all, we said that judgment is the final decision of the court. We know that what are the things which are being stated in the judgment, that has been discussed in detail. Then the judgment has to be intimated to the parties and to the world at large by formal pronouncement or delivery in open court. And the decree is the ultimate outcome by which he can execute that decree, and by means of which he can go to an appeal also. So it is a decree is a requisite for appeal. If he has to go to appeal, he needs a decree. So what are the things which have to be included in a decree, what are the things which are to be included in a judgment, has been discussed by us today in detail. So order 20 prescribes the rules relating to the judgment and decree with respect to the outcome of the case. We have seen the details of this, and the next session will be on interest and costs, section 34. There are certain cases where court allows interest or the cost. So what kind of cost, what is the meaning of this, and what is the importance of this, that will be discussed by the next discussion what we are going to have. So any questions relating to this, you can there may be some questions relating to the case laws which we discussed. That first of all we said that the argument is should be considered by the judge. You must have seen in several cases when the judgment comes in, we find that whatever we have given as arguments, whatever we have given as citations, it has not been considered by the court at all. But of course there is a question again in res judicata. When we were studying res judicata section 11, whatever has not been given by the court has been deemed to be refused. So if a relief is asked for certain point and the court does not give that relief, it is deemed to be refused. That is one thing. Secondly, any point which has been addressed and which has not been taken into consideration there, it is deemed to have been taken into consideration. You have to meet both these things. So in spite of that, in several cases the court has said that for the purpose of justice, it is required that all courts should look into whatever has been submitted by the lawyers, by the advocates, by the parties, and then give their judgments. Then only a proper judgment will be deemed to be given. Yes, any questions on these matters? Any questions? Is it clear? Yes, so we will end the session for today. I think there are no questions. If any questions are there, please post it in the comments and give your feedback. Please share it with all your friends who have not attended, so that they can also share. Of course, whatever your attendance is here, that will be taken in consideration for your attendance, and if it is of use to you, you please share it among your friends and see that it is useful for this subject. Thank you very much.